Last week, we talked a lot about the issue of employment law and some of the legal consequences of hiring, and the fact that it is a contract, and the fact that the contract, like every other contract, can go well or it can go not so well. The thing is, with an employment contract, it is long lasting, as opposed to a normal contract, which tends to last no more than a year. You get the job done for me, job's done, walk away, there we go. An employment contract tends to be an ongoing contract, which is often renewed. But the fact of the matter is that when you hire someone, those people tend to be on for a good period of time. So we've got issues with regards to ending the employment relationship, termination, wrongful dismissal, constructive dismissal. So we've seen those sorts of things. This week, we're going to look at this issue of legislation. And the fact of the matter is because of the fact that employment contracts are so common, and basically, most people will be under some sort of employment contract in their lifetime, or multiple. There has been a whole body of legislation that has been developed over the last, 50, 100 years surrounding employment and what will fill in. The idea is that most of this legislation will fill in the absence of it in an employment contract, but it also sets minimum standards. And that was the important thing from a health and safety perspective and from an equity perspective. So most employers are being forced to do certain things because of employment legislation. So it's important to have a good understanding of what legislation is out there and how it applies. Primarily, what we're looking at is the basic standards of Canadian and Newfoundland employment legislation. Every jurisdiction, because labor is considered provincial jurisdiction, it is every single province and territory has their own employment legislation. Plus, federal government has employment legislation for its employees or people who are governed under federal legislation that's deemed by the Constitution to be effectively federal employees or people who work in entities that are under the control of the federal government. 95% of the population, however, are covered under provincial legislation, and for our purposes, what we're going to do is look at Newfoundland legislation. Okay. So in Canada, across all the board, the generic things that we can say about it is that every province has these minimum standards, and they guarantee worker rights. So it's primarily focused on protecting workers. An employer is free to meet that legislation, and they're also free to exceed that legislation. There's nothing wrong with an employer giving more than what the minimum states, but they can't fall below it, and that is the law. Like other labor legislation, each province has its own, which creates a little bit of a problem in the sense that there are slight variations across the country. The general themes are pretty much the same. What we tend to have is differences in the days or the time periods that are involved, okay? And it covers rights in areas such as hours of work, overtime, minimum wage, vacation, public holidays, coffee breaks, pregnancy leave, parental leave, personal emergency leave, family leave, termination notice, and termination pay. So that tends to be the core things that are found in all of these. Now, what I wanted to do here, though, was to focus primarily on Newfoundland, okay? So the Newfoundland and Labrador employment standards are part of the legislation, that the package of legislation that Newfoundland has, Newfoundland Employment Standards Act. And the labor standards basically set the minimum terms and conditions of work for workers who are under provincial jurisdiction in Newfoundland and Labrador. And as I say, hours of work and these sorts of things are covered. You cannot contract out of those things. So no employer can contract or employee can contract out of that legislation. You can go above it, but you can't go below it. It also lays the groundwork for how labor relations happen in Newfoundland. We'll get into union environments. So we're primarily talking about non-union environments here, but there is another set of legislation that deals with union environments as well. And effectively, the basic rights are covered regardless if you're union or non-union. The provincial government does have a neat little package of information that it does that it has put together in a PDF document. And there's also printed versions of this, but the good thing about PDF versions is that it's always updated. So this is the 2021 version, even though it doesn't state out. And if you go into the slides here, you can actually click on that and go in and get a link to it. So what I've done in my slides, I've summarized from this document, okay? So let's take a look at what we got in that document, primarily with regards to labor law. So Labor Relations Agency in Newfoundland and Labrador supports and promotes the positive employment relationship and administers minimum terms and conditions of employment and provides some sort of a dispute resolution system. The agency provides a number of services to unionized and non-unionized employees and employers throughout the province, such as protection of the basic labor rights of all employees and employers, assisting in resolving workplace issues and negotiating collective agreements, creation of partnerships to promote the currency and relevance of the employment relations regulatory frameworks, such as statutes, regulations, policies, and provides education, training, and support programs to stakeholders. And that booklet that I just referenced is one example of that. So what I've done here is I've basically taken the key components and put in the slides here. So what I want to do is just go through these key issues. So if we look at the benefit on the far left, the qualifiers in the middle, and the entitlement on the right, let's take a look at these various things. First of all, we got something called paid public holidays. And in Newfoundland and Labrador, there are 6 paid public holidays. And from an employer's point of view, what that effectively means is that you have to pay your workers for these holidays, despite the fact that they're not actually working. Okay? So it's an expense from an employer's point of view. It's an expense that you have to cover. From an employee's point of view, it is a day that you're off that you get paid for. We have New Year's Day, Good Friday, Memorial Day, or Canada Day, which Memorial Day and Canada Day are the same in Newfoundland, July 1st, Labor Day, Remembrance Day, and Christmas Day. Many jurisdictions, and this is one of the things that change across the province, many jurisdictions have different days. The core ones are there, but things like Remembrance Day, for example, most provinces is not considered a holiday. So what are the qualifiers? Well, in order for someone to be eligible to qualify for that, if the holiday is worked, there are really no qualifiers. You still get paid for it, and you get paid effectively 2 times the rate for the job plus the day off. So you're making 2 times your pay. If the holiday is not worked, the employee must have been employed at least 30 days before, and work the scheduled shifts before and after the holiday. So it lays out a time frame for who's eligible to collect the dollars from that. So if you only start at work and you got a paid holiday, you don't necessarily get paid. You got to be within 30 days. It's not even prevent the employer from paying you, but it doesn't have to pay. Okay. The entitlement. Well, if you work on that day, you're paid twice your regular rate. If you work 30 days prior to that. If the holiday is not worked, the employee receives an average day pay at the regular rate. If the holiday falls on the employee's normal day off, they receive the next work day off with pay or another day which the employer or employee agree on. In terms of vacation pay, an employee must be employed for at least 5 days with the same employer to be eligible to start collecting vacation pay. And vacation pay is 4% of your gross income. And you ask, where does 4% come from? Well, the legislation says that every employee, once they've worked for a year, they're entitled to 2 weeks holidays paid. 2 weeks represents 4% of the year. So the vacation pay is calculated at 4% of your gross income. So if you made $10,000, you'd make $400 in terms of vacation pay. So the total of pay would be $10,400. The employees who work more than 15 years of continuous service are entitled to more vacation and more vacation pay. So effectively, the legislation says that after you work for someone for 15 years, you're entitled to 3 weeks off, which is the equivalent of 15 days, which is the equivalent to 6% of your gross income. Now, an employer must pay the vacation pay within 1 week of termination of employment or the day immediately before the vacation begins. So there is a stipulation with regards to when payment is to be made. So that's vacation pay. And in terms of vacation time, if you're employed 12 months and have worked 90% of the regular hours in the preceding 12 months, you're entitled to vacation, and that's 2 weeks. If you work for 15 years, you get 3 weeks off. Next, we have sick and family responsibility leave. So most of those leaves, be it sick or family responsibility, and the permutations of those fall under this same category. So you need to be employed by the same employer for at least 30 days before you're eligible for sick or responsibility or family responsibility leave. And at minimum, you're guaranteed 7 unpaid leave days per year. That means that you don't necessarily get paid, but you are entitled to the day off, okay? If you do get paid, that's the employer's prerogative, not the legislation. Pregnancy leave is a big one for half the population. And effectively, pregnancy leave is important from the point of view when you get pregnant. Because if you're employed at least 20 consecutive weeks with the same employer, you are eligible. If you're not employed for 20 consecutive weeks, you're not eligible. So when you get pregnant or when you start work, depending if you're pregnant, it will determine whether or not you're eligible for that pregnancy leave. So you have to be employed at least 20 consecutive weeks before you're eligible for pregnancy leave. And when you go on pregnancy leave, you are eligible for 17 weeks of unpaid leave. In other words, you can take it off for 17 weeks, and your job or a similar job will be there for you when you come back. The employee is responsible for giving 2 weeks written notice prior to going off on leave under normal circumstances. It says, you need a medical certificate from a medical practitioner saying you're pregnant. Sometimes that becomes obvious. And leave cannot start earlier than 17 weeks before the expected birth date. So again, it's 17 weeks before your pregnancy. An employee must give an employer at least 4 weeks written notice if she intends to return to work prior to the end of the 17 weeks. So the fact is that, okay, you're off, you get 17 weeks off, but you have to give 4 weeks notice that you're coming back. Upon return to work, you need to be placed in at least a similar position with the same duties, benefits, and wages. So what that means is that your job may not be there for you when you come back, the same job you left. Another job, however, with the same pay and benefits must be provided to you. Now, they could lay you off. There's nothing to prevent you that. But in terms of a normal operating, the employer has to give you a same or similar job. Then we move on to parental leave. Sometimes we have adoption, so it's not pregnancy leave. What we got parental leave is in the case of adoption. And you're going to see that the same basic rules apply as pregnancy leave, where the employer will has to be have to work 20 consecutive weeks before the adoption. When pregnancy leave is taken, parental leave has to be taken immediately after the pregnancy leave. So the thing is with parental leave too, either parent can take it. And parental leave has to be taken within 35 weeks of the birth of the child coming into custody or coming into the custody for the first time. So effectively, when you've got parental leave, you can take 61 weeks unpaid leave. Employees to give the employer at least 4 weeks notice before they come back, and upon return to work, placed in the same or similar position. In terms of adoption leave, again, very similar in terms of how it works to pregnancy, is that 20 consecutive weeks with the same employer in order to be eligible, 2 weeks written notice that you're going to take the leave, if possible, 17 weeks of unpaid leave once you're off, and 4 weeks notice that you're coming back. Bereavement leave. This is one that unfortunately hits all of us at some point in our career, and that is on the death of a spouse, a child, a grandchild, a mother, a father, brother or sister, grandparent or mother-in-law, father-in-law, sister-in-law, brother-in-law, son-in-law, or daughter-in-law of the employee. So effectively, it lays out what the relationship has to be in order to be eligible for bereavement leave. So you have to be employed 30 days. You'll get the bereavement leave regardless, but you may not get paid. That's the trick. Employed for at least 30 days at the same employer. Employed for less than 30 days. If you're employed for, basically it works this way. If you're employed for at least 30 days with the same employer, you're responsible for, you get 1 day off with pay and 2 days without pay. Total 3 days. If you're employed for less than 30 days, you get 2 days off without pay. So you can see that the bereavement leave is fairly short in Newfoundland. That's by legislation. Again, the employer can go beyond that, and you probably have some combination of sick leave that you would take. But the fact of the matter is that bereavement leave is 3 days maximum, of which 1 of the days would be paid. We also have compassionate care leave, and this is particularly if you're taking care of older parents or like. We have to be, again, employed at least 30 days with the same employer, provide a copy of medical certificate, must provide 2 weeks notice that you intend to take care of the person. So up to 28 weeks of unpaid leave can be taken within 52 weeks to provide care for a family member. So there is legislation out there so that you can do it, but again, it's unpaid. Upon return to work, be placed in the same or similar job, so very similar to the pregnancy. Then we have critical illness leave, and that's a guarantee for if you're employed for 30 days. The employee must provide a copy of medical certificate for a medical practitioner to prove it. The employee must provide 2 weeks notice of the intended amount and date the leave will begin. Sometimes that's impossible, but there it is. You can get up to 37 weeks of unpaid leave to provide care and support to a critically ill child, or up to 17 weeks unpaid leave to provide care and support to a critically ill adult. So a child, 37, an adult, 17. Crime-related child death or disappearance leave. This is a rather new one. So if your child is a victim of a crime, okay? So an employee who's a parent of a child under the age of 18 who has disappeared or died and is probable, or died and is probable, considering the circumstances the child disappeared or died as a result of a crime or a criminal code act, you can get up to 52 weeks of unpaid leave in relation to the disappearance of the child, or up to 104 weeks of unpaid leave in relation to the death of a child. However, the duration of the leave must be limited to that which is reasonably necessary in the circumstances. So, so this is, hopefully none of us would ever have to avail of this. But the employee really can take this sort of thing, and very similar to the other ones that you can 2 weeks notice, this sort of thing. Another one that has come up that is rather recent, I'd say probably 15 years ago, we had a situation where people in the reserves left to go to Afghanistan and they wanted their jobs guaranteed, and the legislation didn't exist. So the government changed legislation. So if you're a member of the Canadian Forces Reserves, and you can get unpaid leave for the required period of the Canadian Forces service. So if you've been employed in employment for at least 6 consecutive months. You're eligible, and once you come back, your reinstatement to your employment. Okay, and then it goes on to talk about others, but again, it's something that is limited to a very specific class. I just want you to be aware that there is such a thing as reservist leave. And again, very similar type of unique type situation, again, that none of us ever fall into, is a family violence leave, where an employee who's been with the employer for 30 days can get 3 days off with pay or 7 days without pay a year in the event of family violence. Communicable disease emergency leave. This is another one of these rare examples where you can get time off for this. So an employee is under individual medical investigation, supervision, and treatment. The employee is acting in accordance with the Public Health Protection Act. So this is coronavirus situation, quarantine, isolation. And again, same sort of thing where you can get 3 days off with pay and 7 days, and so on. With regards to notice of termination of the employee, now this is one that hopefully we don't hit, but too many people do run into this, and that is, what is it that we have to do, or what is it that we're eligible for in terms of notice? Okay, so it depends on how long you've been with the employer. So let's take, for example, if you have been employed with the same employer for less than 3 months, no notice is required. So again, that 3-month window, no notice from you or the employer is required. Once you go over 3 months and up to 2 years, 1 week notice is required. From 2 years to 5 years, 2 weeks notice. From 5 years to 10 years, 3 weeks notice. From 10 years to 15 years, 4 weeks notice. And from 15 years and above, 6 weeks notice. And you can see that the pay in lieu of notice, we talk about wrongful dismissal or these sorts of things. Effective legislation says that if you're out the door, you have to get a notice, or in lieu of notice, you get paid for that period of time. So if it's 1 week notice, you get 1 week's pay. 2 weeks notice, 2 weeks pay, and so on. Okay. Another big one that comes up is hours of work. And what are the hours of work, and what are they limited to? So a work week is a period of 7 continuous days used by the employer. Or the employer doesn't designate a week, a period of 7 continuous days beginning after midnight on Saturday. So starts on Sunday. Employees must be granted 24 consecutive hours off work in each week of employment. There are exceptions in the case of a bunch of things, usually to do with emergencies or some situation that is unique. But for most jobs, you need to have at least 1 day off. The regulations set 40 hours as a standard working week. Overtime is paid when an employee works in excess of the standard working week. An employer shall permit an employee to take, or the employee shall take, at least 8 consecutive hours off. So what that's really saying is that the most you can work in a day is 16 hours. You have to have 8 hours off. That doesn't include the breaks and the lunch period that you have. So employees, unless it's an emergency, again, there are exceptions to all of these, but the thrust of it is that the most you can work is 16 hours a day. If an employee reports to a shift of 3 hours or more and then it's canceled, they must receive at least 3 hours pay. So this is the same if you get called in on overtime. You get called into work, they only need for an hour, they still have to pay you for 3. So essentially, you have to get paid at least 3 hours when you go in. With regards to breaks, subject to some exceptions in the regulation, the employer shall permit an employee to take an unbroken rest period of 1 hour following each consecutive 5 hours of employment. Now, this is interesting. We think about, well, when does lunch come? Well, by legislation, there is no lunch period of 1 hour until you work for 5 hours. So that means you can go to work at 8 o'clock in the morning and not get your lunch until 1. Different rest periods may be established for written or employer contract. So effectively, you can contract above that. You can't contract below it. Unless an employer maintains a right of direction and control during the rest period. So in other words, the employer can still tell you what to do. The employee doesn't get paid for lunch. So if your job is telling you what to do during your lunch period, you should get paid for it. So meetings and extra duties is another thing. So if you got meetings at work that you have to go to, or some extra duties. So employees are required to be paid for the time they spend at the workplace at the employer's request. So if the employer asks you to stay, you have to get paid for it. Examples of when employees should be paid are attending a meeting, end of the workday, and requires mandatory attendance, staying behind, general cleaning, locking up, attending training. So these are all ones that you should be getting paid for. In terms of wages and payments of wages, now this is always changing. So at this point right now, for the period from April 1 to 2021 to September 30th, 2021, the minimum wage is $12.50 an hour. For the period October to March 31st, 2022, the minimum wage will be $12.75 an hour. Future adjustments will be based on the annual consumer price index for Canada. The new rate will be announced annually by the government on April 1st. So effectively, they're doing away with changing the minimum wage. They're just going to, whatever the consumer price index is, it will get indexed. So effectively, it will keep up with inflation. Then it says the minimum overtime wage rate is 1.5 times the minimum wage. Employers must pay an employee no less than half monthly. All wages owing must be paid within 7 days of the end of the pay period. The employer must pay the wages, in check or go into your bank account, these sorts of things. It lays out how it has to be done. Tips and gratuities are the property of the employee to whom it is paid, not the employer. Now, just something, a little bit of an underpinning here with regards to the minimum wage. It says the minimum overtime rate is 1.5 times the minimum wage. And that's important because most of us think the minimum wage, most of us think that overtime pay is 1.5 times a regular rate. That's not necessarily true. It is 1.5 times the minimum wage rate. So they really, if the minimum wage rate is $12.50 an hour, then $6.25 on top of that, so that's $18.75 is the rate for time and a half. So even though your salary might be more than that, you think that you get 1.5 times your wage. At that, no, legislation says 1.5 times minimum wage rate. We discussed a little bit about vacation pay there above in the things, in the little tables. And effectively, this 4% of gross wages if you're there less than 15 years, 6% if you're there more than 15 years. Vacation pay, like everything else, is taxed, and the tax is taken out of it, the employment insurance contributions, Canada pension plan, so there's deductions that come out of it. Got to be paid 1 day before going on vacation, so you go with some money in your pocket. And if you don't qualify for annual vacation, there's still entitlement to vacation pay provided the employee has been employed for more than 5 working days. So what that means, it's you can't take your vacation until you've been there a year, but let's assume you get laid off just shy of a year, they're still responsible for paying you the vacation pay for that period of time. So that adds up. That's effectively, it could be up to 2 weeks in salary. So don't walk away without that. And it's an expense to an employer that an employer needs to be aware. An employee who qualifies for vacation pay must be paid within 1 week of termination. Sadly, the fact is our gross pay is not what we get in our wallet. What we get in our wallet is the gross pay less all the deductions. And here are the legal deductions that an employer can deduct. Income tax, Canada pension plan, employment insurance, overpayment of wages, deductions of group benefit plans, savings plans deductions, overpayments on unused portions of travel advances, rental charges when the employee occupies the employer's premises, and sums deducted or withheld by court order. So again, there's a number of things that can come out of your check. And the employer is responsible from the employer's perspective. They're responsible for collecting those things in the case, for example, taxes, kind of pension plans, and court orders. An employer shall not require an employee to pay for uniforms where the uniform is unique to the business. So if you've got a Tim Hortons uniform, that got Tim Hortons written on it, they have to pay for it. You do not have to pay for it. Now, if it's a blue shirt that you can wear outside regular, you may have to pay for that. It has to be unique to the employer. Okay? So if an employee damages the employer's property, product, or has an outstanding account with the employer can't deduct that amount from the wages.